Okay, they are not there.
Auditor Mason case item 40, second appeal paper 1 of 2006.
Yes.
They had mentioned, the appellants had mentioned based from the IA that they have referred for stay of the execution proceedings petition.
Are you ready to argue the case?
Actually, I'm not ready today because I was informed yesterday that it will be mentioned today. One thing, and second thing, Your Ladyship, is the matter was taken up thrice. They have not pressed the application, they took time. On 16/6/22, 2/8/22, and 16/8/22. Finally, the second appeal was dismissed. It was thereafter restored, it stood dismissed on 11/10/22. Thereafter, it was restored. The restoration application was filed in 23. After restoration, it has now been restored.
And now they are pressing the earlier
Yes.
line.
And the execution is also at the fag end, Your Ladyship. The amount has been deposited for deployment of funds. The receipt has been
So that is
generated.
why I want to hear it finally, but if you are not ready, we have no option but to see.
It may be posted tomorrow at the ready, at 2:50 or any time.
There is one case fixed for tomorrow at 10:30, which we are going to continue. Auto matter. What is the question of law?
There was only two questions of law which was framed by order dated 5/3/2009. And you released one more thing, there are other respondents also who are contesting. I am only appearing for respondent number 1, not for the others.
Who is appealing for others? Yes, madam? You should just. I number 16559 of 2025 has been filed for early hearing of this appeal. Counsel for the respondent has no objection for fixing a date. Rather, he says that if the matter is posted tomorrow, he shall get ready and argue the case finally.
CA will not be available tomorrow. It will matter day after tomorrow.
To this, the counsel for the applicant has submitted that her senior may not be available tomorrow. She will said the matter will be posted day after. ID number 16559 of 2025 is allowed. The matter is directed to be posted for final disposal day after tomorrow, to be taken up immediately after the case, which is already fixed as one first case. एक already fixed है, उसके बाद आपका case take up. Upon perusal of second substantial question of law, which is widely worded Counsel for the appellant has submitted that the materials which he will be pressing with respect to substantial question of law number 2 is exhibit 8, 8 by A, exhibit C, I dash 1 by 1 and I dash 1 by 2, and evidence of PW 6, 7 and 8.
With your lordship permission, minutes, I may only indicate minutes. Only evidence of 2 witnesses will be relevant. PW3, PW7.
That's all?
PW3, PW7.
Okay. Yes, इसको काट के लिखिए. I
And
submitted that only evidence of 2 witnesses would be relevant. That is PW3
and PW7.
PW3 and
PW7.
PW7.
And so far as exhibit lordships, exhibit 1, which is the safety which they are relying upon, that may also be taken into consideration.
And he shall also be placing exhibit 1,
G.
I or 1.
Exhibit 1, evidence which the salient which they are relying upon.
They are the plaintiffs.
They are the plaintiffs.
Exhibit 1, which is the sale deed relied upon by the plaintiff.
Lordships.
These 3 evidences on record would be sufficient to dispose of the
But apart
substantial
from
question of law.
Exhibit 8A and
ये क्या कहानी बोल रहे हैं?
but see, सिर्फ witnesses का था, but so far as the witnesses are concerned,
You just say that exhibit 1.
Exhibit 1 and previously lordship has recorded exhibit 8A by
Exactly.
A.
Yeah,
That may also be taken into consideration.
Exhibit 1 is the sale deed. Exhibit 8 क्या है?
8 is the khatiyan which they are relying upon.
8 is the khatiyan.
And 8 by A is the khatiyan of the so-called grandfather of the plaintiff 1917 का, जिसमें कह रहे हैं कि
Exhibit 8 and 8 by A,
Gotcha.
which are the 2 khatiyans exhibited by the plaintiff. That is all.
And exhibit C is the sale deed of the defendant.
The learned counsel submits that he shall also rely upon exhibit C, which is the sale deed of the defendant.
Lordship.
So you have PW3, PW7,
Lordships.
you have exhibit 8, 8 by A,
Lordships.
and exhibit C.
It's apart from that,
That's
we will
apart.
place the pleadings, lordship, the plaintiff and
वो
double
तो
for your lordship and
invariably
consideration.
that will be there only.
Lordship.
You see, he also submits that the pleading of the these evidence is to be considered in the light of the pleading of the respective parties. That's all. Person. आप बना लेंगे नोट?
Yes.
आप भी बनाइए नोट बना
Yes,
के
we
लेंगे।
have although we have prepared a lordship short
Like-
note, lordship.
इसको इसमें लगा देंगे और उनको याद दिलाइए इसको देख के आना। और कोई आइए
There is an IE for stay members because
आइए नंबर
IE number is lordship 12274 of 2025
और
and IE for early hearing as well.
और ये फिर अलाउ कर दीजिए दूसरा आइए एक तो आइए दूसरा ये कौन सा
12275 and 16559.
12275 of 25 and
16559.
ये दोनों आइए है ना फॉर अर्ली हियरिंग एक्ट्स और ये आइए अभी क्लोज नहीं कर रहे हैं आपका स्टे वी विल हियर इट
Day after tomorrow.
या
ये तो
Okay.
अभी ही क्लोज है दोनों.
अर्ली हियरिंग
Okay.
एक ऑलरेडी फिक्स है 10:30 बजे उसके बाद
Okay.
For hearing on order 41/11 item 34, second appeal 216 of 2018.
This matter was heard by your Lordship on the last date, that is on 12th of January 2026 in Washington DC. This is judgment and decree of the appellate court against the dead person. Then your Lordship noted down the gist of the facts and asked the learned counsel appearing for the respondent.
Where is he?
That day, Lord, prayer was sought for on his behalf.
Who was appearing?
Junior counsel to him. The name is
Zaid Ahmed. Mr. Zaid Ahmed was appearing.
one judgment of the Honorable Coordinate Bench with your Lordship. Another judgment I will permitted to, because by the time he comes, Lord, I just Lordship will go through it. The difference between this case and the other two cases, one, the Lordship already on record, and another which I have placed before Lordship.
Which is on record. I am not able to put it.
When the coordinate bench judgment which your Lordship intends to rely upon that
No,
day.
there is one more. There is one judgment already referred.
Yes. Yes, your Lordship must be referred.
Next with the name.
देखो अलग से हुजूर के पास था वो दिए था हमको देखो पढ़ने दिए थे जो ये दिए एक ही चीज हम लोग कोऑर्डिनेट में चीज दिस है
Bashir Mia died on 16/3/2000.
यस
Human Mia 2008 and Muslim Mia died on 3/11/2010. Correct?
यस नाउ द लॉर्डशिप में कैन रिटर्न टू the appellate court judgment, the cause title. Appellate court judgment cause title. Yaqub Mia and Rafiq Mia referred the appeal, although the other one was also the Juman Mia and Munna Mia were the plaintiffs.
They are pro forma.
Pro forma, they were made pro forma in the appeal. Number of the Basir Mia was the contesting respondent along with others appellants. Who are the appellants? Nabi Mia and others. They are the appellants. Here in the second appeal.
Even in the suit, he was separately made party.
Yes. You will see, just see the judgment of the learned trial court.
Bashir Mia. Yes. Bashir Mia was separately made party.
Decree.
We'll hold that it is a nullity. If they don't want
Yes.
to come, that is their problem. We can't do
Proper
it.
not unnecessary. The law says so.
We'll hold that it is a nullity. The suit was for
The suit was filed
for
for declaration of title and recovery of possession.
it's a judgment of reversal.
Judgment of reversal. There are two plaintiffs originally Srimati Vindhya Devi, then she was substituted by these two respondents, Juman Mia.
Now the liberty has to be reserved with the respondents.
Unless
Divide the appeal.
unless they pray. That in that case the appellants made a prayer because the
We'll keep it open to them.
as
If they want to revive it within 2 months, it's okay.
that is
And
the
those persons who have expired, they will take steps because there are all these
in
persons who
accordance
have-
with
We keep it open to them. Okay, second appeal number 216 of 2018. This appeal has been filed against the judgment and decree dated 4th September 2017, within bracket decree signed on 11/9/2017, bracket close, passed by Learned District Judge Roman 5 Dhanbad, entitled appeal number 118 of 2007, reversing the judgment and decree dated 27th of June 2007, within bracket decree signed on 9/7/2007, bracket close, passed by Learned Sub-Judge Roman 5 Dhanbad, entitled suit number 118 of 1998. The Learned Counsel for the appellant has submitted that the suit was filed for a declaration of title and recovery of possession with respect to the scheduled property, and the suit was dismissed. Consequently,
Yaqub Mia and Rafiq Mia, both sons of late Ramjan Mia, prefer this title appeal number.
plaintiff कौन?
Plaintiff हुए थे, originally plaintiff थे वो जो India the PV. You know, so just see the degree of
Yes,
your.
I'm seeing the degree.
हाँ,
Where do I get this Yaqub Mia?
Yes, India BB was substituted by one B and one Juman Mia, Munna Mia,
अच्छा अच्छा.
Muslim Mia and Yaqub Mia.
Okay.
One A, one B, one
That's
C.
it. The Learned Counsel submits that the suit was originally filed by Bindia BP. Video of late Ramzan Mia,
Yes.
who was substituted at the stage of suit itself
Yes.
by Juman Mia, Munna Mia, Muslim Mia, Yaqub Mia, and Rafiq Mia.
Yes. All sons of late Ramjan.
All sons of late Ramzan Mia. He submits that when the suit was dismissed, the two persons, Yaqub Mia and Rafiq Mia, they filed appeal before the first appellate court,
Title appeal number 118 by 2000.
titled appeal number 118 of 2007, and the other three sons of Ramjan Mia were made pro forma respondents in the appeal.
As respond number 1, 2 and 3. Performer respond number 1,
As
2
pro
and 3.
forma respond number 1, 2 and 3 respectively. The Learned Counsel submits that Basir Mia expired on 16/3/2008, Juman Mia in the year 2008, and Muslim Mia on 3/11/2010. The appeal was decided on 4th of September 2017, and thus one of the contesting defendant and two of the substituted co-plaintiffs had expired during the pendency of the appeal. And the first appellate court had reversed the judgment and decree passed by the Learned Trial Court. Consequently, the respondents in the first appeal, who were the defendants, are the appellants before this court. Yes?
Lordship, father of arguing counsel has expired.
बेबी 2:15 बजे से आप कहाँ थे? बेबी
Lordship, I was not present. I got the call, so I came here early.
आपका सब लिखा रहते हैं, अगला डेट में ऑर्डर करेंगे. I will not record your presence. एकदम लास्ट में लिखा. ये कौन सा तरीका है? बाय डिफॉल्ट एडजर्न हो जाए तो बहुत अच्छी बात. When will he be available?
Lordship, he told me that 1 week time.
Just hold. The learned counsel has submitted that the appellants before this court इनके भी तो लीगल ईयर्स होंगे, बसीर मियाँ के भी लीगल ईयर्स
हम
हैं।
उसको भी सब्स्टिट्यूट नहीं किए, हम यहाँ अपील वसील मियाँ को छोड़ के बाकी लोगों से कराए।
Sons of late बसीर मियाँ है तो यहाँ पर बसीर।
Yes, sir.
The learned counsel submits that Sagir Mia and Aslam Mia are the co-appellants before this court, who are sons of late Basir Mia,
वसील मियाँ।
and it has come on record that Basir Mia, Jumman Mia, and Muslim Mia had expired on their postal dates. The learned counsel submits that the impugned judgment passed by the learned first appellate court is a nullity, and consequently the judgment be set aside. He submits that at best the appellants before the first appellate court, that is Yaqub Mia and Rafiq Mia, can take steps before the first appellate court for the purposes of substitution, which may be considered as per.
In view of the judgment
He
details.
has relied upon the judgment passed by this court in second appeal number 112 of 2021, decided on 24/1/2023,
Relying upon Supreme Court.
which in turn has been relied upon, relied
2005.
upon by in the judgment passed by the Honorable Supreme Court reported in bracket 2005 bracket 26 SSC. नाम बताइए अपना।
Zaid Ahmed.
आपका नाम जैद है ना?
Yes,
दूसरा जज अहमद को बोला ना, वो नहीं।
he is MT Zaid Ahmed.
आपका भी नाम जैद है ना?
Yeah, Lordship, Zaid Ahmed.
मतलब आपका और उनका नाम सेम है?
वही हम भी सोच रहे थे जज
No,
अहमद।
his name is MT Zaid Ahmed. Like
And
my
your name?
only Zaid Ahmed.
हम भी पहले वही सोचे थे उनके बारे में, ये वो नहीं है। Let's take your process brief.
हाँ। ये तो बड़ा मुश्किल है ना? उनका नाम जैद इमाम है। Mr. Zaid Ahmed, assisting counsel of Mr. Zaid Imam.
No, arguing counsel is Ankit Barman, Lordship.
हाँ। पिछली बार कौन आए थे? जैद अहमद। आप भी?
Yes, that time I took time on the grounds of like his father was critical arguing.
अच्छा अच्छा।
This time I got the information that his father has passed away.
Mr. Zaid Ahmed, advocate, submits that the father of the arguing counsel at this stage of the dictation, Mr. Zaid Ahmed, the assisting counsel of the arguing counsel, namely
Ankit Barman.
Ankit Barman, has submitted that on account of death of father of Ankit Barman, he is unable to appear before this court, and prays that the matter be posted in the next week. आज कितना है? आज Tuesday? Post on next Tuesday. To be taken up as first case at 10. हाँ, the first case for disposal is there, for final disposal is there. For final disposal करते हैं।
Item 35, second appeal 207 of 2019.
Short password reading. Immune Council is in court number 16.
Who is your guy in council?
Rajiv Ranjan.
What time?
Short password after 2-3 days.
At 3:15.
Much.
Item 36, second appeal 63 of 2020.
Yes, please.
Lordship, had it been a general case, like non-tribal case, there was no substantial question of law emerging from the entire case review. But since it is a tribal dispute between Munda and Munda, and case of identification of agnates without identifying the killie of both the sides, it cannot be decided who is the actual killie. Killie means clan, गोत्र, और एक गोत्र में शादी नहीं होती है जैसे हम लोगों में होती है। तो अगर एग्नेट्स कहते हैं कि ये जमीन मेरी है तो उनकी किल्ली, और जो ये कहते हैं जो डिसीज्ड हैं, जो सनलेस हैं, अगर उनकी किल्ली टैली करती है तो एग्नेट्स हैं, अगर टैली नहीं करती है तो एग्नेट्स नहीं है। और हमारे पास एफिडेविट है लॉर्डशिप जिसमें डिसीज्ड पर्सन्स आर ऑफ हस्सा क्लान, हस्सा किल्ली, whereas the people claiming as agnates they belong to Tarayada killi, Tarayada killi. So though both the killis differ from each other, they cannot claim as the agnates of the deceased persons. Secondly,
The deceased persons, they belong to which family?
Hassa killi. Killi means clan, lineage.
And
Taraiva killi.
they are the defendants.
The difference.
They were the defendants.
No. Taraiva killi is quite different from Hassa killi. Agnates कौन होगा? मेरा हस्सा किल्ली का
Who
ही
claims
होगा
to be
ना?
the agnate? The plaintiffs or the defendants?
No, defendants are agnates ना. Plaintiff are from the deceased side. Appellants are from the deceased sides.
From Hassa.
From Hassa. दूसरी बात कि कोर्ट को भी थोड़ा सोचना चाहिए था. Something they should have taken into consideration before deciding the issue, to go for examination of the Munda, Manki and Parha suo motu under Order 16 Rule 14.
You see, we are not in we are in second appeal. You just come to the findings and what were the issues framed by the court.
Findings, Lordship,
Issues framed by the court. Was there any issue framed as to whether they are the
it's
agnates
okay.
or not?
So I am telling, before initiating the argument, I told frankly that had it been a general case, I don't have any objection with the order and decree of the court. I don't have any objection. Since it is a case of the tribe versus tribe, the court should have considered and suo motu called for examination of the Munda, Manki and Parha in order to get the real agnates in this case. And affidavits are available with me, where both the parties are of different killings, not of the same killings. And it's also Article 244(1) mandates Schedule 5 of the Constitution for its implementation and preservation of the customary rules and rights of the scheduled tribes in scheduled tribe area.
Deputy Commissioner was a party. What was
But
the
Deputy Commissioner never appeared.
Never appeared, that's your problem, we do not.
But
He was
they-
a necessary party and he became a party in the proceedings.
But law is involved, Lordship. Law points are there, so many law points involved in the case, and each and every point of time it has been ignored. कम से
Each
कम
and every
कोर्ट
point of time means, now you
कम
will
से
say,
कम हुजूर कम से कम कोर्ट को तो चाहिए था ना कि सुओ मोटो ट्राइबल एरिया में
आप लोग को क्या चाहिए था?
हम गलत थे, हम गलत थे, हम नहीं प्रोड्यूस कर
सेकेंड अपील में उसको ठीक
सके,
कर
हम
सकते
प्रोड्यूस
हैं।
नहीं कर सके, लॉर्डशिप आई एक्सेप्ट इट।
तो सेकेंड अपील में हम उसको कैसे ठीक करेंगे?
तो आपको तो
Under what provision of law can I do it?
आपको तो
You see, these people are poor tribals, but advocates are not poor people.
राइट
Then विद्वान अधिवक्ता बोलते हैं आप लोग को ना, तो
विद्वान
विद्वान की तरह काम किया करिए।
कम से कम एक चांस दीजिए।
कोई चांस नहीं मिल सकता है। देखिए स्पेसिफिक इशू फ्रेम हुआ था, इशू नंबर 2।
I have gone through, हमको कोई ऑब्जेक्शन नहीं है उससे।
कुछ नहीं कर, सेकेंड अपील में हम कुछ नहीं कर सकते हैं। अधिवक्ताओं को हम पुअर अधिवक्ता नहीं बना सकते, ठीक है? पुअर इन नॉलेज नहीं बना सकते।
यहाँ तो मान लीजिए
नहीं मान सकते कैसे? मतलब देयर इज नो प्रोविजन अंडर व्हिच आई कैन रियली इंटरफेयर। रिट पिटीशन थोड़ी है,
क्योंकि एडिशनल एविडेंस तो ले ही सकते हैं ना 41 रूल 27 में।
आप बियॉन्ड लॉ बहस कर सकते हैं, हम नहीं कर पाएंगे ऑर्डर बियॉन्ड लॉ।
एफिडेविट है, लॉर्डशिप एफिडेविट देख लिया जाए, और जब तक क्लियरली एस्टेब्लिश नहीं होता है, एग्नेस का एस्टेब्लिशमेंट नहीं होना चाहिए, नहीं होता। कम से कम एडमिट कर लिया जाए, जैसा होगा देखा जाएगा बाद, बिकॉज सो मेनी लॉ पॉइंट्स आर इन्वॉल्वड हियर।
और चलेंगे counsel appearing on behalf of the applicant. This appeal has been filed against the judgment and decree dated 30/11/2019 and 6/12/2019 respectively, passed by learned district and additional sessions judge 1 Kuti in civil appeal within bracket title appeal number 17 of 2010, whereby the appeal has been dismissed. The suit involved in this case is title suit number 20 of 2019, sorry, 20 of 1991, wherein judgment has been passed on 10/12/2009, in bracket decree signed on 19/12/2009, whereby the learned Munsif Civil Court Kuti has dismissed the suit. Has allowed the suit on contest against defendant number 1 to 29 and ex parte against defendant number 30. The plaintiffs had filed the suit for a declaration that they have acquired occupancy right, title and interest over the suit land, and for confirmation of their possession. And also prayed that the defendants be directed to mutate the name of the plaintiffs and rent receipts be granted to the plaintiffs. The appeal filed by the some of the defendants was dismissed by the learned first appellate. Consequently, the appellants before the learned first appellate court are the appellants before this court. The learned counsel for the appellant has submitted that though there are concurrent findings in connection with the family of the plaintiffs and the defendants, though there are concurrent findings with regard to the issue as to whether the plaintiffs were the nearest agents of the recorded tenant of Khata in bracket RS back close number 48, 49, 52 and 53 of the village but the matter has not been properly examined in as much as the learned courts have failed to consider that the tribals were the parties before the court and the learned court ought to have been more careful and ought to have called for further evidence from the parties. The learned counsel submits that under such circumstances, the impugned judgment cannot be sustained in the example. After hearing the learned counsel for the applicant, this court finds that the specific case of the plaintiff was that they are the settled rayat of village Odra, PS Putti district Ranchi, in bracket now Putti, and have rayati land in the village under Mundari Patidar of the village. Whereas the defendants are the Mundari Patidars of the village, who used to realize rent from the tenants. The parties are mundas governed by customary law, where females are excluded from inheritance. Pandey Munda, son of Karam Singh Munda, recorded tenant of Iris Khata number 52 and 53, died leaving behind his only son, Panda Munda, who died unmarried, leaving behind the plaintiffs as agnates, who came in exclusive possession of the property. Jeet Munda, son of Bhanva Munda, was recorded tenant of RS Khata number 48 and 49, who died leaving behind his son, Bharva Munda, Bharwa Munda, who also died sonless, and the plaintiffs are the heirs and legal representatives who came in possession of the land and started cultivation. Without any objection from the widow of Bharva Munda, who also died within a short time. The plaintiff gave a genealogy showing the relationship with the recorded tenant with respect to Khata number 52, 53, 48 and 49. It was asserted that the defendants are the Mundari Kutta landlord and they were only entitled to rent. It was already fixed, but they were avoiding to grant rent receipt. And were threatening the plaintiffs. And consequently, the suit was filed. The defendant number 1 to 21 contested the suit and asserted that the plaintiffs are strangers and have no concern with the true property, and asserted that they were not related with the recorded tenant. The defendant number 22 to 30 were the Pahan of the village, Karore, Karore. It was asserted that defendant number 22 to 30 had lost the case against the defendant number 1 to 21 relating to some of the khatas of land under Kewat number 3/21 in partition suit number 58/4 of 1980-82 of the appellate court in title appeal number 82 of 1982. And they, with the collusion of the plaintiffs, had filed a suit, present suit against defendant number 1 to 21. It was asserted that defendant number 1 to 21 are the Munda of the village, and they are the Mundadi Kutkattidar of the village, and plaintiffs are Rayyat under defendant number 1 to 21. Defendant number 22 to 36 were the Pahans of the village Karura. It was asserted that the recorded tenant of the land in the suit and their sons and heirs died issueless, and therefore the defendant number 1 to 21 resumed the land and came in possession thereof. The plaintiffs wanted to grab the suit land with the collusion of defendant number 22 to 30. A written statement was filed on behalf of defendant number 22, 23, 25, 26, 27, 28 and 29, asserting that the plaintiffs are the strangers and they have no concern with the suit property. It was also asserted that they are not related to the recorded tenants, and there was no cause of action for the plaintiff to file the suit. And that the plaintiffs are not the agnates of the recorded tenants. Defendant number 15A had filed a separate written statement, who adopted the written statement filed by defendant number 1 to 21. Defendant number 22 within bracket A to 22 within bracket C had also filed a separate written statement, asserting that the suit was barred by law of limitation and adverse possession. And disputed the genealogical table given by the plaintiff, and asserted that the plaintiffs are not the agnates of the recorded tenant, and therefore they were not entitled to inherit the property of the recorded tenant. Defendant numbers 16A and 16B had also adopted the written statement of defendant number 1 to 21. The learned trial court had framed the following issues for consideration. Considering the argument of the learned counsel for the appellant, the core issue is issue number 2. The learned trial court after considering the materials on record held that the plaintiffs were able to prove the genealogy on the basis of the evidences placed on record. And ultimately decided issue number 2 and 3 in favor of the plaintiffs. The plaintiffs were also found in possession of the property. The learned first appellate court also considered the materials on record and observed the admitted facts of the parties in paragraph number 13 as follows. 13 को quote करें. The disputed facts of the parties to be adjudged has been recorded in para number 14. इसको quote करें. The learned first appellate court recorded that the plaintiffs had categorically stated that they are the nearest agents of the recorded tenant and have categorically established such fact not only by documentary but also oral evidences. The points for adjudication as framed by the first appellate court is in para 16, which is as under. The learned first appellate court has recorded that the plaintiffs has established a relationship with the recorded tenant, and apart from 3 other witnesses like PW1, PW2 and PW3, the plaintiffs have also examined PW4, Ramdeen Mundai, who was the daughter of the recorded tenant Pandi Munda, who had categorically established the genealogy as given by the plaintiffs and had also established that the plaintiffs were the agnates or nearest Nayar of the recorded tenant. The court recorded that this fact has not been controverted by the defendants, even after thorough cross-examination of this witness. It stood admitted that Ramdeen Mundai is the daughter of the recorded tenant Pandey Munda and the only surviving family member of the Pandey. As DW2, Karam Singh Munda, who was also one of the defendants, himself admitted in para 25 of his deposition that Pandey had 4 daughters, Ramdeep, Ramya, Radu Devi and Sona. Even the defendant witness number 4, Hari Singh Munda, had stated in his deposition that Pandey had 4 daughters. Out of them, 3 had died. The learned court relied upon the evidence of PW4 Ramdev Mundai and found that she has proved the genealogy of the plaintiffs. The learned first appellate court considered all the materials on record and ultimately held that gave concurrent findings with respect to the genealogy and that the plaintiffs were the nearest agnates of the recorded tenant D. Munda and Pandey Munda. So, after the death of their male successor, as per Munda's customary law, land of Khata number 48, 49, 52 and 53 was inherited by the nearest bhaiyad of the recorded tenant, who were the plaintiffs before the court. The learned first appellate court also considered the other issue regarding resumption of land by the defendants, as the specific case of the defendant number 1 to 21 was that they, being the Kutkatidar of Moza Karora, had resumed the land of Khata number 48, 49, 52 and 53, which was recorded in the name of Deep Munda and Pandey Munda, after the sale was abandoned after the death of their last male successor. The court considered the materials on record and ultimately held that the defendants have failed to establish, ultimately held that till 1986, land of Khata number 52 and 53 was being cultivated by Panda Munda. Until 1988, land of Khata number 48 and 49 was being cultivated by wife of Bharua Munda and daughter-in-law of the recorded tenant Deep Munda. So there was no question of the suit lands being resumed by Kutkatidar till 1988. The suit was filed in the year 1991. So it was the duty of the defendants to establish that when and under what circumstances they found the suit land to be abandoned and had resumed the same, being Kutkatidar. The court also recorded that such fact has not been established by the defendant number 1 to 21, and therefore the plea of resumption of land has not been established by the defendants even on the principles of preponderance of probability. The court was of the view that the learned trial court had rightly decreed the suit. Ultimately, the learned first appellate court, after discussing the materials on record, dismissed the appeal. This court finds that the parties had contested the suit and evidence was led from both the sides. And ultimately, the court decreed the suit. There is no substantial question of law involved in this case. This appeal is accordingly dismissed.
Lordship, at least two substantial question of law my memo 3 and 6 may be take place in the order.
आपके ऑर्डर डिक्टेशन के बाद आपका कोई भी सबमिशन हम रिकॉर्ड नहीं करेंगे.
हम इसलिए चुप रहे कि बॉर्डर डिक्लेरेशन और डिस्टर्ब होता है इसलिए।
उसके बाद तो कुछ नहीं हो सकता।
Assault case Section 35, Second Appeal 207 of 2019.
But the defendant responded another appellate matters. These appellates were defendant matters, suit was dismissed. Thereafter, matter suit was allowed, decree was reversed and suit was allowed, and one of the defendants is filing this second appeal. The case of the plaintiff matter in this case is related to with the land of Khata number 94, lot number 103, area 0.92 acres, out of which matter 62 decimals is in dispute. But the case of the plaintiff was that the said land was recorded in the name of Mangra Pujar, Lora Pujar, Magu Pujar, the sons of Gandra Pujar, and Mosmat Ghasni, wife of Dunhaura. It is further case, their case is where these recorded tenants have surrendered the said land in the year 1937 and subsequent thereto the landlord, ex-landlord Lal Kandarpal Sadil has settled the said land in favor of the plaintiff by Hukunama coupled with rent receipts, and further their case is that there is a community also.
There is oral settlement.
Oral settlement, it is stated that oral settlement subsequently Hukunama and
There is
community.
a hukum. What is that exhibit?
उसका एक ओरल सेटलमेंट है, उसका रेंट रिसिप्ट से इसको फॉलो किया गया।
कबूलियत कहाँ?
रजिस्टर्ड कबूलियत है।
कहाँ है? exhibit number?
एग्जिबिट रजिस्टर्ड कबूलियत है। नहीं, रजिस्टर्ड कबूलियत नहीं है। इनका एग्जिबिट 1 बाय ए है, रेंट रिसिप्ट, एग्जिबिट 2 to 2 बाय बी, 3 जमींदारी रिसिप्ट, एग्जिबिट 3 सर्टिफाइड कॉपी ऑफ इस्तीफा पट्टा, एग्जिबिट 4 सर्टिफाइड कॉपी ऑफ कबूलियत पट्टा, नंबर 16 कबूलियत पट्टा है एग्जिबिट 4। एंड आफ्टर हुकुमनामा डेटेड 17/8/36, एग्जिबिट सी सर्टिफाइड कॉपी ऑफ ऑर्डर ऑफ कॉपी। इसमें द ट्रायल, इसमें उनका मेन कंटेंशन ये था कि इट वाज सरेंडर्ड इन द ईयर 1937। स्पेसिफिक केस है इनका कि पारा 4 में स्पेसिफिक ऑफ द प्लेट स्पेसिफिक बोले कि ये सारे लोगों ने सरेंडर कर दिया, एक्सीलेंट लॉर्ड ने हमें सेटल कर दिया। नाउ द लर्नेड ट्रायल कोर्ट, और हमारा केस ये है कि ये लोग जो 4 आदमी थे ये ऑल डाइड इशूलेस एक्सेप्ट लोहरा पुजर वाज हैविंग वन सन जल्हा पुजर। जल्हा पुजर की वाइफ थी गंदूरी, और वो गंदूरी जो है 1993 में गिफ्ट डीड से सेटल दिस लैंड्स टू these defendants who are the son of her daughter. Go gifted it with permission of the deputy commissioner. She gifted the property. Now the learned trial court while considering the order, इसका है बहुत छोटा सा ऑर्डर है, हम खाली ऑर्डर पढ़ देते हैं कंसीडरेशन। पारा 14 में पारा 14 ऑफ द ट्रायल कोर्ट। After hearing the both sides, internal page 8. This is type.
Internal page?
8. Yes.
नहीं, आप यहाँ से पढ़िए। पैरा नंबर 12.
Paragraph से. Then the defendant counsel has argued the matter that the plaintiff suit is barred by under section 34 of the specific agreement recorded against Mangra Pujar, Lohra Pujar and Mago Pujar, son of Mangra Pujar, has not surrendered this sea land to ex-landlord Maharaja Baranam Kandapula Sadil in 1937, and in absence of surrender, no question of resettlement arises. No rent receipt has been issued in favor of Ramcharitar Saw, nor he has paid any rent to state. It is further argued the matter that Ramcharitar Saw never came in possession of the property. It is further submitted that Jalha Pujar has not filed any proceeding under section 71A of CLT Act. In 1983, plaintiff forcefully disposes the defendant. It is further argued the matter that Khata number 94 belongs to scheduled tribe and no one can settle the ST land to non-ST. The documents which have been filed by the plaintiff are false. It is further argued the matter that in 1993, Jalha Pujar and his wife
Gandri Urai, after taking permission, transferred the suit land along with other land by registered gift deed to Kamal Urao and Pula Urao, and on the basis of gift deed mutation has been allowed in their name. It is further argued the matter that SAR case number 10 of 2006-2007 has been decided in favor of defendant and the land was restored in favor of defendant. At present, defendant is in possession of the suit land. It is further argued the matter that plaintiff have produced total 9 witnesses, out of them PW1, 2, 3, 4, 5, 8 are formal witnesses who have only proved the rate receipts, PW6, 7, 9 who have failed to prove the possession of the plaintiff against the defendant. I produced, again that defendants have produced 10 witnesses and all the witnesses have fully supported the claim of defendants. It is further argued the matter that the case of the plaintiff is barred by under section 34 of the Specific Relief Act, so plaintiff is not entitled for any relief. The plaintiff counsel has argued the matter that Khata number 94 is recorded in the name of Mangara Pujar, Lohara Pujar, Mago Pujar, who have voluntarily surrendered the land of plot number 103, Khata number 94 to the then landlord Maharaja Barala Kandarpuna Sahib and put the landlord in possession. Then landlord already settles 0.62 acres of land of plot number 103, Khata number 94 on dated 17 July 1937 and put the settlee Ramcharan Saw, grandfather of plaintiff grandfather has executed registered community number 279736 in favor of landlord for taking settlement of the land. Thereafter, Ramcharan Saw paid rent regularly and remained in possession. After death of Sitaram Saw, plaintiff being the son, legal heir came in possession and remanded in possession. Jala Pujar initiated proceeding under section 71 which was decided against him in SAR case number 8 of 1973-74. Again, Jala Pujar filed SAR case number 12 of 41 against plaintiff's father for restoration of land which was again dismissed, but defendant number 1 by suppressing the real fact and material filed SAR case number 10 of 2006-7 filed which has been decided against the plaintiff, against which he has filed an appeal which was also dismissed. It is further submitted that the plaintiff is in possession and rightful owner of the suit land. He has further argued the matter that he has produced 9 witnesses and produced documentary evidence. All the witnesses have fully supported the case of plaintiff, so the right title interest of the plaintiff may be declared on the suit land which is described in schedule. After hearing both sides, I peruse the record. I find that it is admitted that the suit land of Khata number 94 is recorded in the name of Mangara Pujar, Lohara Pujar and Mago Pujar, son of Gandra Pujar and Mosmat Ghasni in Khadian. Plaintiff's case is that recorded tenant has surrendered the suit land in favor of them, then landlord Maharaja Barala Kandarpuna Sahib in 1934. By deed number 523-34. In para 17 of the plaintiff has stated that in the year 1937, recorded tenant surrendered the land to then landlord and landlord orally settled the land on dated 17/8/36 and put the settlee in possession. When I go through the deed number 523 of the 34 Exhibit 3, I find that the settlement was executed by only one recorded tenant, Mangara Pujar, before executing Exhibit 4. No settlement in writing has been made in favor of plaintiff's grandfather. Perusal of record, I find that the plaintiff has produced a bunch of plaintiff's and Malgujari receipt, but plaintiff has not brought on record any such document which shows Jamabandi has been opened in register to in the name of plaintiff's grandfather and rate receipt does not confer any right title. Perusal of the record, I also find that the plaintiff has brought this suit only to declare right title interest of the plaintiff over the suit land and the degree for confirmation of possession. But when I go through the record, I find that the defendant has filed his WS and in para 14 he has stated that after taking permission, Jalha Pujar, son of recorded Rayat and wife of Gandura Urao, gifted the suit land along with other land to defendant Kamal Urao and Bhola Urao by registered gift deed, and SAR case number 10/067 has also been brought by the Kamal Urao and plaintiff was also very aware from this fact that this title has transferred in the name of Kamal Urao through registered gift deed, but in his plan he has not made any submission for the
This was Set aside by the appellate court.
This was set aside.
What is the reason?
नथिंग मतलब इशेज
Nothing मतलब ऐसा
बढ़ जाता है जो खाली जजमेंट को कोर्ट किया है कि इसमें ऑनरेबल कोर्ट ने ये कहा, इसमें ऑनरेबल कोर्ट ने ये कहा, इसका स्पेसिफिक आंसर कहीं नहीं दिया है। जितना ये है इसको हम कर देते हैं यहाँ से
What is the point for determination?
वो तो फ्रेमिंग है। यहाँ पे पारा 11 से स्टार्ट किया है, पेज 14।
कितना इसमें SAR केस हुआ?
इसमें जो एज पर द प्लेंटिफ केस है कि 73 और 78 में कोई एसआर केस फाइल हुआ, बट नथिंग हैज ब्रॉट ऑन रिकॉर्ड टू सब्सटेंशिएट द सेट एविडेंस। डिफेंडेंट का केस
What
था
about SAR case of the year, SAR appeal number 31 of 2007?
वो तो मेरे फॉर्म में डिसाइड हुआ, दैट वाज प्रिफर्ड बाय द प्लेंटिफ एंड डिसमिस्ड।
Dismissed.
हम डिपेंडेंट थे, मतलब हमारा एसआर अलाउ हुआ, उसके अगेंस्ट में वो अपील गए और अपील हार, एंड देन neither he challenged both two orders passed by the SAR court in this suit, ना ही वो गिव डीड को चैलेंज किए। पूरा प्लेट में हजूर कहीं ये नहीं लिखे हैं कि जो सेटलमेंट था दैट वाज बाय करता, पूरा प्लेट उनका ये कहता है कि 37 में तीनों जितना रिकॉर्डेड टेंडेंट थे उन्होंने सरेंडर कर दिया। अब नाउ अपीलेट कोर्ट में वो प्ली लिए कि नहीं, मंगरा पूजर वाज करता ऑफ द फैमिली एंड इन दैट कैपेसिटी ही हैज एक्सक्यूटेड द सरेंडर डीड ऑफ 1934, जबकि उनका प्लेट में क्लियर कट प्लीडिंग है कि 37 में जो है सरेंडर हुआ एंड देन ऑल दिस थिंग्स।
क्या substantial question of law?
First has A. Whether the learned or appellate court has committed grave error of law in reversing the judgment of learned trial court without meeting the ground set forth by the learned trial court and reversing the same only on the basis of conjecture and surmises, which is wholly unjustified. Second बनाया मेरे हिसाब से B. Whether the learned or appellate court has committed grave error of law in coming to the conclusion that the surrender made by Mangra Pujar was as Karta of the family and there is no requirement of others to join, and as such the same surrender is valid, whereas no such evidence was made by either of the party to show that Mangra Pujar was Karta of the family. Moreover, the defendant has denied and specifically asserted that the surrender deed is forged and fabricated and the same confers no title on the plaintiff and has the finding of the learned lower appellate court on this point is very perverse. उसका तो जजमेंट का है, उसकी जजमेंट का मिस इंटरप्रिटेशन है। फिर ई whether the learned or appellate court has further committed grave error of law in misinterpreting the judgment as reported in appellate decree number so and so and came to erroneous finding that present suit is maintainable and the bar of section 258 of CNT Act is not applicable, whereas the portion quoted by the learned or appellate court itself clearly indicates that the suit is maintainable only in case where fraud or want of jurisdiction is alleged. तो ऐसा इसमें कुछ नहीं किया। Pleading is there by the plaintiff despite the same learned court has erroneously come to conclusion that the bar of 258 is not directed, which is only unjust and unsustainable in the law. If G has whether the learned lower appellate court has further committed violation of law that the present suit is filed for setting aside the orders passed by SAR officer as well as the appellate court. However, the plaintiff has not prayed for any such relief and hence the judgment and decree is illegal, purpose and unsustainable in the year. And then lastly, H. Whether the learned lower appellate court without any basis have considered issue with regard to right of Adivasi women to sell or transfer the property and has given erroneous finding which is not at all warranted in the facts of the present case as such the improved judgment and decree is wholly unjust and unsustainable in the, because in this case the gift deed, if they would have challenged the gift deed, then the question of Adivasi women could have arisen. Whether she was completed, not completed, whether the order of the deputy commissioner allowing her to gift the property was justified or not.
Gift deed was not challenged.
No, that
It
was the
was not
finding.
disclosed also by the plaintiff. Was it disclosed by the plaintiff?
No, इसको हम कुछ
You are
तो हमारा
relied upon
ऐसे
that.
ऐसे यार मेरा पूरा केस ही वही था कि गिफ्ट डीड से हमको मिला.
Heard the learned counsel appearing on behalf of the appellant. The learned counsel has submitted that the learned trial court had dismissed the suit and the learned first appellate court has allowed the appeal. In spite of the fact that the defendant was claiming title over the property by virtue of registered gift deed. And the legality of the registered gift deed was never challenged by the plaintiff in the suit. Rather, the plaintiff had not even disclosed that there was a registered gift deed in connection with the property involved in this case. The learned counsel has further submitted that in a proceeding initiated under section 71 capital A of Tobacco Tenancy Act, the same was decided in favor of the defendant. Lastly, in SAR case number 10 of 2006. Okay, enough.
और अपील का नंबर 31
Against which appeal was also dismissed, bearing number
31 of 2007.
31 of 2007. After hearing the learned counsel for the appellant, this appeal is admitted for final hearing on the following substantial question of fact. एसआर ऑफिसर का ऑर्डर चैलेंज किया था?
नहीं,
नहीं challenge
उसको
किया। तो आप ये क्या लिखे हैं?
अब जी में उसी में बनाया है।
Present suit is filed for setting aside the order of SAR.
ये लगता है कि होना चाहिए।
F में भी वही लिखे हैं।
नहीं, जी में लिखे हैं, जी में स्पेशल
F और G दोनों में लिखे हैं।
whether the landed law update to the further complete waiver of law that the suit is filed for setting aside the orders in the officer as well as the appellate court, however the plaintiff has not paid for any such relief. बाद में लिखा है, paid for any such relief and have the judgment and duty is illegal purpose.
Whether the learned first appellate court has failed to consider the whether the learned first appellate court has failed to consider that the suit property was already transferred by way of a registered gift, which was never challenged by the plaintiff in the suit. इतना हो जाए क्योंकि आपका SAR का ऑर्डर भी तो उसी पे बेस्ड है।
एक मिनट एक को कर दिया जाए कि without meeting the grounds of the landed trial court. उसमें सारा दो ही पॉइंट पे उनकी थी कि था कि 34 का because gift deed has not been challenged, so therefore gift deed is stands then the property is in the name of defendant.
जहाँ आपका फर्स्ट सब्जेक्ट बनाएंगे ना रिमार्क करना
ये वाला बना दीजिए कि फर्स्ट अपडेट को जो करता कंसीडर कर लिया है
हाँ
उसको करेक्ट
whether the learned first appellate court has committed perversity in holding that the surrender was made by Mangra Pujari in the capacity of Karta of the family. इस पे कोई pleading भी नहीं होगा। The learned counsel ऊपर लिखेगा. The learned counsel for the appellant has also submitted that there was no foundation pleading that Mangra Pujari was the Karta of the family. But still the learned first appellate court has recorded such matter. Issue notice to the respondents for which requisite under कहाँ है आपके respondents? Issue notice to the ये deputy commissioner को क्यों बोलेंगे?
डिप्टी कमिश्नर की कॉपी दे दूंगा।
हाँ, issue notice to the respondents. Since the deputy commissioner is to be represented by the office of learned advocate general, let 2 copies of the memo of appeal with enclosures and synopsis be served upon the office of learned advocate general, who shall appoint an advocate to assist this court in the matter. Let notice be issued to the respondent number 1 through the concerned police station, for which requisite be filed within a period of 1 week from today, entry. Let the records be called for from the concerned court. Let this order be completed. Post on February.
Item 27, second appeal 144 of 2023.
second appeal is not by the plaintiff, appellant. Not the prayer for the suit was filed by the plaintiff's appellant for declaration that the defendant number 3 is not the adopted daughter of the plaintiff number 1 and the adoption deed is illegal, void and inoperative in law and the same may be cancelled.
Registered deed?
Registered.
Hindus?
Hindus. Now, Lord, your worship may kindly see for a moment. The learned trial court, the case of the plaintiff's lord in short, that the plaintiff number 1 was suffering from paralysis since last 15 years. Thereafter, not fraudulently, the said registered deed was executed and registered, and he came to know in the December 2003, and the suit was filed from the certified copy when they disturbed the possession of the plaintiffs over the suit.
Adoption, just a moment.
Now, Lord, your worship may
Just a
kindly-
moment.
Yes.
The suit was filed
For-
by whom?
By
the
the-
adoptive father.
Adopted father, plaintiff number 1.
Plaintiff number 1 is the adoptive father.
Adopted father. And so far the defendants are concerned, they are the persons who got the registered deed of adoption executed. That is Kausalya Devi 1A, daughter of late Satal Chaudhary, and Bharat Kumar, Srimati Usha Devi, and Kiran Kumar is the adopted daughter, the alleged adopted daughter, Kiran Kumar. Now, Lordship may kindly see the trial court judgment. Lordship may kindly see.
What are the issues?
Yes, that is the. Or the appellate court judgment, your Lordship may kindly turn para 5. Para 5. Appellate court judgment.
First, para 4.
Para 4. Yes. Para 5 may be issues.
Para 4 may be issues.
Para 4. Para 4 में the case of the defendants.
आप कौन सा देखते क्या देखते हैं?
Appellate court का judgment हुजूर शुरू में बाद वाला ट्रायल हो जाएगा. पेज नंबर 11. पेज 11.
पहले ट्राई करते
ट्रायल नरसिम्हा
हैं. इंटरनल पेज 11, para number 4.
Yes. Para 4. Is the suit maintainable whether the plaintiffs have valid cause of action? Whether the plaintiff number 1 Baski Chaudhary is a disabled person suffering from paralytic attack since last over 15 years. Number 4, is the plaintiff Manoj Chaudhary has been looking after the affairs of plaintiff number 1 as guardian. Whether the defendant number 3, main issue is not, whether the defendant number 3 Kiran Kumari has actually legally validly taken in adoption by plaintiff number 1 and given in adoption by defendant number 1 and 2. 6, whether the adoption deed number 78 of 1996 has legally and validly been created and has the plaintiff number 1 ever executed the said adoption deed illegal, void, false and inoperative.
You see, you have not filed any document regarding your medical condition.
Yes, Lordship just see the documents which were filed
No.
and
you
what
see,
has been
issue number
discussed.
3.
No, that is order 41 rule 27 rejected.
That's right.
Rejected.
We are
But
looking
you
at
know-
the trial court judgment.
But yes, trial court judgment, I am just coming to
Yes.
Lordship, the documents which were on record and which were discussed by the learned trial court. Lordship just see for a moment, paragraph.
सर ट्रायल कोर्ट का फाइंडिंग पढ़ रहे हैं ना, एप्रोप्रिएट कोर्ट
पेज
में मांगने
16, पेज 16,
पेज 13 में पहले
पेज
13 के बाद ही 16 आया.
हाँ 13 के बाद ही पढ़ रहे हैं 16.
पहले 13 पढ़ी.
13 पढ़.
Issue number 3 is decided
Yes.
against you.
Issue para
No
number 9.
document filed.
Para number 9. Issue number 3, yes.
Yes.
No document.
No
Plaintiffs have
document.
nothing filed.
Issue number 4
That is
not
the.
pressed. This
I am
was not
coming to
pressed.
issue number 5 and 6.
Filed.
Para 9. Then your Lordship may kindly, both these issues are very important issues to decide this suit, and as such both are being taken up. The plaintiff pleaded plaintiff number 1 never adopted Kiran Kumari as his adopted daughter. When he came to know that Satal Chaudhary and his wife managed to execute a false and fabricated adoption deed of 1996, whereas plaintiff never adopted said Kiran Kumari as his adopted daughter, not giving and taking ceremonies was held in the village. None of the locality known the fact of the said adoption. It is further pleaded that the plaintiff that the defendant managed to stand a fake person in place of the plaintiff who put his LTI on the said adoption deed. As such, the said adoption deed was executed, which is false, fabricated, and inoperative, and there is no relation to the plaintiff number 1. In this regard, plaintiffs have produced altogether 5 witnesses in support of their version, and pleading all of them have stated in the fact the plaintiff number 1 never adopted Kiran Kumari as his adopted daughter. On the other hand, the defendant pleaded that the plaintiff number 1 has executed an adoption deed such and such voluntarily and after performing all rituals, rites and customs prevail in the society for adoption. After passing time and years of connivance of the other plaintiffs, one changed his mindset, and in the instigation of Manoj Chaudhary and other persons filed the present suit for cancellation of adoption deed with ulterior motive, whereas the valid adoption was performed by both parties, in which all the formalities were done, and the plaintiff number 1 voluntarily adopted Kiran Kumari as his adopted daughter as executed on adoption deed number such and such. The defendant produced and examined altogether 6 witnesses who supported the factum of pleading of the defendant and plaintiff number 1 voluntarily adopted Kiran Kumari as his adopted daughter. Both parties filed exhibited documents. Plaintiffs have filed certified copy of adoption deed, whereas the defendants have filed original adoption deed. Both have marked Exhibit 1 and Exhibit A respectively. Apart from this, plaintiff have certified copy of deposition of Satal Chaudhary, examined in title suit number 28 by 2005, in which Satal Chaudhary filed the same suit for cancellation of Abhishek Chaudhary. And in cross-examination, he said that I cannot say the date of birth of my daughter Kiran Kumari. I did not get marriage of Kiran Kumari and did not perform dan of her. He further stated that no ritual for adoption was taken place in the house. The plaintiffs have to prove that whether adoption deed was executed or not. But besides oral evidence, there is no documentary evidence in this regard, and the LTI in the adoption deed was not challenged. Besides this, the plaintiff have not brought before the court the said Kiran Kumari after taking adoption, alleged did not change the name of her father in the school certificate, or ration card, or Aadhaar card, or admission registered in school certificate, etc. It has further not been proved that the said Kiran Kumari was residing with her natural father, mother in place of adoptive father. Instead of the plaintiffs themselves filed a certified copy of deposition of Satal Chaudhary, which was marked as Exhibit 2, disclosed the fact that the natural father of Kiran Kumari did not get marriage of said Kiran Kumari, did not perform dan of said Kiran Kumari, which goes against the plaintiff. How it is inconsistent. It is not barred by law that adopted daughter is not giving and taking in adoption. Besides this, the suit has been filed more than 8 years of the execution of adoption deed number such and such. It was pleaded that the plaintiff number has no knowledge about the said adoption nor believable. There are sufficient documentary evidence produced by the plaintiff, such as ration card, identity card, Aadhaar card, SLC, CLC, admission register of the school or other documents which disclose the fact that the father name of Kiran Kumari is Satal Chaudhary or Basuki Chaudhary. After going through the case record evidences available on the case record, either on behalf of the plaintiffs and defendant, it is very clear that the plaintiffs have got succeeded to prove both the issues in their favor, and both issues are accordingly decided against the plaintiff. Have not succeeded. So my humble submission is, Lord, that for the purposes of adoption, your Lordship is correct in section 16 says if it is done in terms of compliance of section 6 to 12.
Execution of the registered
Yes, there is a presumptive value. There is a presumptive value. But at the same time, section 8 to 12 are the pre-sections to the section 16. So that the plea which was taken, that it is to be proved, and it is for the person who said it to be a genuine one. Then the presumption will come. Then genuine one. That is, Your Lordship may kindly see appellate court also in the same line. If Your Lordship may kindly come to paragraph 10, only point for determination. Then the learned trial court dismissed the suit on the ground of delay. Now the appellate court
No,
framed
not only on the ground of.
no, this is one of the
The
ground.
court has taken.
One of the yes, one of the ground, sir. One of the ground. The Lordship may kindly see paragraph 10, page 13. Paragraph 10, page 13.
Yes.
Only one point, whether the adoption deed dated such and such is genuine one or not. This is the only point. And so far other issues are concerned, they have been left over, no discussion.
No. Genuineness of this will cover everything.
No, limitation, everything is there. If it is barred by limitation, that was all one of the points raised not in the trial court by them, and that was decided that it was deemed, although it has come within few months, it has been filed. Article 58 has been ignored. Article 58 of the Limitation Act. When the cause of action
The
first approved.
appellate court has not decided, has not
I am
discussed
just
on the
showing
ground
the
of limitation. The appellate court has
decided on the ground of limitation.
No, the
that
appellate court has decided on the merit of the case.
merit, and then
You forget about
also
limitation.
all the findings are confirmed
Yes.
by the appellate court. You know, just see para 11 onwards.
Do you want to say that the suit was barred by limitation? No,
No, it is not barred.
it is
But
not.
the learned trial court.
Learned trial court must have stated that
But
there was
the-
no issue framed in
but-
connection with point
But
of
the appellate
limitation.
court says, Lord,
That's
having
right.
on record given in aforesaid such and such, I find there is no error in the judgment of the trial court.
That is it.
Error.
That will not call for
Error.
a
Therefore,
substantial
Lord,
question.
now this one you also may kindly see.
All questions of law are not substantial question. The appellate court has not said that the suit was barred by limitation. Has it said?
Not in
No.
so many words.
So that
But
is
in
all.
affirm
That
the
is your
judgment of the trial
favor.
court.
Maybe affirm the judgment.
Now your Lordship may kindly come to Lord directly, para 13. After discussion of oral evidence, I am not reading the oral evidence. Para 13, page 20.
Yes.
In the light of arguments raised by both parties. It is arguments by the learned counsel wherein the appellant pleaded that the plaintiff number 1 never adopted Kiran Kumari as his adopted daughter, and when he came to know that Satal Chaudhary and his wife managed to execute a false and fabricated adoption deed number 78 of 1996, whereas the appellants never adopted the said Kiran Kumari as his adopted daughter, no giving and taking ceremonies was held in the village, and none of the locality knew the fact of the said adoption. It is further pleading of the plaintiff that the defendant managed to stand a fake person in place of plaintiff number 1, who put his LTI on the said adoption deed, and as such the said adoption deed was executed, which is false, fabricated and inoperative, and there is no relation to the plaintiff number 1. In this regard, appellant has produced altogether 5 witnesses in support of their version and pleading, and all of them have stated the fact the plaintiff number 1 never adopted Kiran Kumari as his adopted daughter. On the other hand, the defendant pleaded that the plaintiff number 1 has executed, so this is the pleading of the defendant, plaintiff number 1 executed an adoption deed by its number voluntarily after performing all rituals. This is the plea taken by the defendant. All rituals, rites and customs prevail in the society for adoption. After passing time and years in connivance with plaintiff number 1 changed his mindset up, and in instigation of the Manoj Chaudhary and other person filed the present suit for cancellation of adoption deed with ulterior motive, whereas a valid adoption was performed by both the parties in which all formalities were done, and the plaintiff number 1 voluntarily adopted Kiran Kumari as his adopted daughter as executed adoption deed number such and such. The defendant produced and examined altogether 6 witnesses who supported the factum of pleading of the defendant that the plaintiff number 1 voluntarily adopted Kiran Kumari as his adopted daughter. Both parties filed exhibit documents as well as plaintiffs have filed certified copy of adoption deed, and whereas the defendant also filed original deed, both marked exhibit 1 and A respectively. Apart from this, plaintiffs filed a certified copy of deposition of Satal Chaudhary, the defendant number 1, or the natural father of the defendant number 3, examined in title suit number 28 of 2005, in which the Satal Chaudhary filed the said suit for cancellation of Abhishek Chaudhary. In his cross-examination that he cannot say the date of birth of his daughter. So this is required under section 6, 8 and 9 of the Hindu Adoption and Maintenance Act, which are mandatory in nature. Daughter, namely Kiran Kumar, he did not get marriage of Kiran Kumar. He did not perform dan of her. So he says that he did not give any dan. He further stated that no ritual for adoption was taken place in his house. Besides this, appellants have not brought before this court the said Kiran Kumari, after taking adoption, as alleged, did not change the name of her father in school certificate, etc. So natural father's name carried out in all the certificates. If the adoption story was correct, so subsequent certificates showing the name of natural father, not the adopted father. She never went to the house of adopted father. This is his statement, and that is admission in view of section 58 of the Indian Evidence Act. Facts admitted need not be proved. So therefore the onus which was on the defendants to prove that section 6 to 8 were complied with, and then presumption will die. Otherwise not. It must be within the four corners of section 6 to 8 of the Hindu Adoption and Maintenance Act. And then when he categorically says he does not know the no adoption done, then when he says that all the certificates carry the name of natural father, she never went to the house of the.
Where is the finding that all the certificates carry the name of natural father?
Then that is the admission.
वो ठीक से नहीं लिखा है, आप हमको बताइए कहाँ पर है?
Finding
All the
वही तो जो हम खोज रहे थे. Find this is exhibit 2. Exhibit 2 is the certified copy of deposition of Satal Chaudhary, the natural father, in another case, where he admitted all these facts, and that was also
admitted means
admitted these facts which I have read just now, and those facts which are admitted.
those documents have not been exhibited
No,
over here.
no document was exhibited, but the admission is exhibit 2, and that is the reason exhibit 2 was placed for reliance upon. And that is the reason why I was referring section 58 of the Indian Evidence Act. Lordship may kindly see. Section 58 says that facts admitted need not be proved, and the onus is upon the defendants to prove.
On the basis of deposition, when he is referring to certain certificates, those certificates should have been brought on record by
But
exhibits.
this is their possession. That is the reason I say, Lord, if you also may kindly see section 58 of the Indian Evidence Act. 58.
Evidence Act नहीं है।
Evidence. No fact need be proved in any proceeding which the parties thereto or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleading in force such and such, and are deemed to have been admitted by their pleading. Facts admitted need not be proved. Similarly, in a proceeding, he deposed Satal Chaudhary is none else but the natural father, and that has been filed as Exhibit 2, and the Exhibit 2 no answer to it by both the courts, and in relation to section 16, 6 to 8 of the Hindu Adoption Act, Adoption and Maintenance Act, no finding. Simply they say, we have said no, nothing has been followed. They say it has been followed. So it was for them to prove that there was a valid adoption, and then presumption will carry. The learned appellate court did not take into consideration.
The document was exhibited. That document has not been held to be a invalid document. The deed of adoption has not been held to be forged and fabricated. Correct?
Yes, yes.
So there is a presumption in
The
connection.
presumption, but before we come to deed of adoption, that is section 16, you also just see on the next page also, page 22.
What is the meaning of this in which Sakal Chaudhary filed a suit for cancellation of Abhishek Chaudhary? What is
वही
this?
तो वर्ड मिसिंग है, दोनों को एक ही वर्ड, उसका भी लैंग्वेज वही है, हम भी खोज नहीं पाए क्या पता अभिषेक चौधरी कौन है और क्या सूट था, कैंसलेशन ऑफ अभिषेक चौधरी, दैट इज शॉर्ट लग रहा, लेकिन एडमिशन उनका है, एविडेंस दिए थे उसमें, एड्यूस किए थे, एग्जिबिट 2 इज द डॉक्यूमेंट बिफोर दिस कोर्ट, दोनों को वही लिखा, सेम लैंग्वेज लिखा, अब उसमें लिख रहे हैं देयर आर but you will also just see point number section 6 to 8 of the Hindu Adoption and Maintenance Act, how the adoption is to be maintained. The father does not know the age of the girl at the time of adoption or at the time of his evidence. She did not go to the adopted father after execution of the registered deed. She in her all certificates, school living, college living, ration card, voter card, everywhere, the name of natural father, Satal Chaudhary, not Basuki Chaudhary. That is an admitted position by the plaintiff defendant number 1 in his evidence.
अब ऐसा करिए तो
जी
हम खोले हैं एपीलेट कोर्ट का जजमेंट
जी
पैरा नंबर 13 ट्रायल कोर्ट का फाइंडिंग पढ़ी, हमको तो लगता है एकदम कॉपी पेस्ट कर दिया।
हम वही तो बोल रहे हैं,
पढ़िए सर,
पैरा 13
हम पैरा 13 में हैं, आप ट्रायल कोर्ट का जजमेंट
जी बिल्कुल, ट्रायल कोर्ट का
ट्रायल कोर्ट का पेज नंबर 14 में है।
हाँ जी जी
द प्लेंटिफ्स प्लीडेड से शुरू करें।
जी जी, yes both these issues mass important.
पढ़ी?
The plaintiff pleaded.
Yes.
The plaintiff number 1 never adopted Kiran Kumari as his adopted daughter, and when he came to know that Satal Chaudhary and his wife managed to execute a false and fabricated adoption deed number 78 of 96, whereas the plaintiffs never adopted said Kiran Kumari as his adopted daughter, no giving and taking ceremonies was held in the village. None of the locality know that the fact no new होगा तो we know लिखा है, we know लिखा है. The fact of the said adoption, it is further pleading of the plaintiffs that the defendant managed to stand a fake person in a place of plaintiff number 1 who put his LTI on the said adoption deed, and as such the said adoption deed was executed, which is false, fabricated and inoperative, and there is no relation to the plaintiff number 1. In this regard, the plaintiffs have produced altogether 5 witnesses in support of their versions and pleading, and all of them have stated the fact that the plaintiff number 1 never adopted Kiran Kumari as his adopted daughter. On the other hand, the defendant pleaded the plaintiff number 1 has executed an adoption deed by number 78 of 96 voluntarily after performing all rituals, rites and customs prevailed in the society for adoption. After passing time and years in connivance of the others, the plaintiff number 1 changed his mindset and in the investigation of Manoj Chaudhary, another person filed the present suit for cancellation of adoption deed with ulterior motive, whereas a valid adoption was performed by both the parties in which all formalities were done. And the plaintiff number 1 voluntarily adopted Kiran Kumari as his adopted daughter and executed adoption deed number 78 of 96. The defendant produced and examined altogether 6 witnesses who supported the factum of pleading of the defendant. The plaintiff number 1 voluntarily adopted Kiran Kumari as adopted daughter. Both parties filed and exhibited documents. Plaintiffs have filed certified copy of adoption deed number 78 of 96, whereas the defendants have filed original adoption deed number 78 of 96. Both have been marked as Exhibit 1 and Exhibit A respectively. Apart from this, plaintiff have a certified copy of deposition of Satal Chaudhary examined in title suit number 28 of 2005, in which the said Satal Chaudhary filed the said suit for cancellation of Abhishek Chaudhary. in his cross-examination that I cannot say the date of birth of my daughter Kiran Kumari. I did not get marriage of Kiran Kumari. I did not perform dawn of her. He further stated that no ritual for adoption was taken place in his house, in the house. The plaintiffs have to prove that whether adoption deed was executed or not. But besides oral and evidence, there is no documentary evidence in this regard, and the LTI in the adoption deed was not challenged. Besides, the plaintiffs have not brought before the court that the said Kiran Kumari, after taking adoption as alleged, did not change the name of her father in the school certificate or ration card or Aadhaar card or admission register in school, etc. It has further not been proved that the said Kiran Kumari was residing with her natural father and mother in place of adoptive father. ये तो उनका काम है प्रूव करना, हम करेंगे. Instead of that, the plaintiffs themselves filed certified copy of deposition of Sital Chaudhary, which was marked as exhibit 2, disclosed the fact that the natural father of said Kiran Kumari did not get marriage of said Kiran Kumari, did not perform dawn of Kiran Kumari, which goes against the plaintiff version. It is not barred by law that daughter is not living and taking in adoption. Besides this, the suit has been filed more than 8 years of execution of adoption deed, and it was pleaded that the plaintiff number 1 has no knowledge about the said adoption deed is not believable. There are insufficient documentary evidence produced by the plaintiffs such as ration card, identity card, Aadhaar card, SLC, CLC, admission register of the school or other document which disclose the fact that the father's name of Kiran Kumari is whether Satal Chaudhary or Basuki Chaudhary. After going through the case record, evidence is available on case record, either on behalf of the plaintiffs or document. It is very clear that the plaintiffs have not succeeded to prove both these issues in their favor, and both issues are accordingly decided against the plaintiffs. Exactly वही उतार दिया. Just see. And it is their case, the onus would lie then upon them. The learned court of appellate court added 2 lines more. It is very clear in center of judgment, catena of judgment, the Honorable Apex Court has laid down. Some discrepancies may occur in the testimonies of the rustic and rural person that must be discarded by the court at the time of their application. But it will not override the mandatory.
The learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the suit was filed challenging the deed of adoption of defendant number 3.
Exhibit 1.
Within bracket exhibit 1. Registered deed of adoption. He has referred to the findings recorded by the learned trial court. As well as the learned first appellate court. With regard to the core issue, which was relating to issue number 5 and 6 as decided by the learned trial court, and the learned counsel has submitted that the findings of the learned trial court and the learned appellate court is almost the same. And even the grammatical error in both the judgment is the same, correct, Mr. Sani? Mr. Sani? Even the grammatical error are the same.
एग्जैक्टली हम लोग भी कॉपी पेस्ट करते हैं ड्राफ्ट में कभी कभी छूट जाता है
The learned counsel submits that the specific case of the plaintiff was that no ritual of giving and taking of the adopted daughter was performed, and though the registered deed of adoption carries presumption in the eyes of law, but once it is denied that no ritual was performed,
nor she
It was-
ever lived with the adopted father.
And she did not even live with the adopted father. It was for the defendant to prove the adoption by quoting evidence, which the defendant has failed to prove.
Next one, page number 7, memo copy.
This appeal is admitted for final hearing on the following substantial question of law. 2 and 3 to get. इससे हो जाएगा?
Now, sis,
Issue notice to the respondents through the concerned police station for which requisite be filed within a period of 1 week from today, that the records be called for from the concerned court. Post on 26th February.
contrary.
26 February.
For judgment, item 1, second appeal 26 of 1998.
This appeal is dismissed.
For orders to take effect, item number 14, first appeal filing number 1590 of 2025.
स्टेट फाइल किया पोच कर लेते हैं 2023 का ये एक्सेप्शन का पेंडिंग है वो डिफेक्ट में रखना है
इसमें डिफेक्टिव है क्या?
यस
Yes? क्या बोलना है?
इसमें तो हमें तो कुर्फी के लिए 2 weeks टाइम तो लेट्स से 2 weeks टाइम लेकिन इसमें तो नहीं आया रिपोर्ट
क्या नहीं रिपोर्ट आया?
फर्स्ट आइटम में कि जो करेक्शन के लिए गया
आपका कॉपी से दीजिएगा तो करेक्शन करवा के क्या करेंगे हम?
कुर्फी के लिए हम 2 weeks टाइम दिया एज ए लास्ट इंटेलिजेंस हमें चूंकि रिक्वेस्ट लेटर भी वहाँ से आया है और
परसों नहीं करना।
नहीं कि कुर्फी के लिए हम जमा करने के तत्पर हैं अभी जस्ट आज ही के लेटर आया है
कॉपी हमको कम्युनिकेट हुई।
2 साल हो गया एक्सक्यूशन भी पेंडिंग है, उसमें अटैच होने का भी कुछ ऑर्डर भी हो गया सर, अमाउंट हो गया
जो भी होगा हम देखेंगे।
एक हफ्ता से ज़्यादा का हम आपको टाइम देंगे।
ठीक।
FA नंबर 1590 of 2025। ये सारा बैच है अभी लगा हुआ।
हाँ 5 केस
3 सेकंड।
तो 4 ही केस है।
आज 5 केस है।
5 में से 4 सेम होगा, एक जो है उसका अलग है, उनका दूसरे अवार्ड को दूसरे जजमेंट को चलना चाहिए, दूसरा प्रोजेक्ट ही वो अलग है।
सब में कोर्ट फीस का डिफेक्ट है।
सब में कोर्ट फीस का डिफेक्ट है। एक में गया था उसमें आ भी गया है रेक्टिफाई होकर जो कॉल टाइटल में था डिफेक्ट पार्टी पोजीशन उसमें आ गया है। लास्ट आइटम जो 1709 था उसमें।
ठीक है, सब में कोर्ट फीस का डिफेक्ट है।
हाँ कोर्ट फीस का डिफेक्ट सब है।
The counsel for the appellant prays for and is granted time till 3rd of February to deposit the deficit court fees as pointed out by the office. Failing which this appeal shall stand dismissed without reference to a bench. If the defects are removed within, if the aforesaid defect is removed within time, owes this case on टू को है क्या कुछ केसेस आ रहे हैं?
हाँ
कुछ आ रहे हैं 12/2। Pose this case on 12/2/26. Office is directed to send express reminder for भेजा गया होगा ना इसका।
फर्स्ट आइटम भेजा गया है उसमें नहीं आया है। लास्ट वाला आइटम जो इसके साथ है बैच में 1709 उसमें करेक्ट हो गया है।
To the concerned court for sending the impugned judgment and decree. So decree भेजा गया था impugned award after correction. किसमें नहीं आया है? आइटम नंबर 1 में नहीं आया।
हाँ 1590
और बाकी सब में आ गया है।
बाकी सब में देख लेंगे।
बाकी सब में आ गया है।
हाँ एक ही भेजा गया था 1709 उसमें आ गया है।
4 केस है ना।
तो बाकी में नहीं भेजा गया, बाकी में सिर्फ कोर्ट फी का ही डिफेक्ट है।
अच्छा ओके, सिर्फ इसी का करेंगे। ये इन फाइलिंग नंबर 1509।
छोटा मिस्टेक है पेरेंट का नेम पर ही है और कुछ नहीं। 1590 प्रिंटेड
बाकी में तो नहीं है ना, सिर्फ इसी में है वो। हाँ ठीक है, कोर्ट का सामने है वो तो प्रिंटरी ऑर्डर करनी चाहिए।
1590 में प्रिंटरी नहीं किया, बाकी में प्रिंटरी कर दिया जाए।
सर क्यों 1590 में
क्योंकि वहाँ से रिपोर्ट नहीं आया है।
डेफिसिट कोर्ट फीस तो लिखा हुआ है।
हाँ तो इट में भी इंडिकेटेड रिलेटिंग टू डेफिसिट कोर्ट फी।
हम सिर्फ प्रिंटरी ऑर्डर सिर्फ रिलेटिंग टू डेफिसिट कोर्ट फीस, पहले आप कोर्ट फीस जमा करें।
14 20 10 हुआ
सब एक ही साथ अलग अलग है क्या सब केसेस?
केस अलग अलग है
सब में कोर्ट फी भी अलग अलग है।
सब में कोर्ट फीस सब खाली कोर्ट फीस का ऑर्डर करेंगे सब।
Item 19 second appeal file number 10492 of 1025.
May it please the Lord. Now, on the last occasion, the lower court records was called on. There is one surviving defect, my lord.
एलसीआर आ गया
उसमें मतलब एक surviving defect था.
डिफेक्टिव केस में एलसीआर कॉल कर सकते हैं
मतलब the reason was,
बहुत बड़ा एरर
मतलब the reason was,
डिफेक्टिव क्यों आ गया केस?
the reason was that the internal page 10 of the original court's judgment is not legible. And on that, my lord. But उसमें what I have seen कि उसमें the same defects survive.
जो है सो अब उसी को पढ़ेंगे हम तो पढ़ लेंगे आप अपना सोच लीजिए आपको कैसे पढ़ेंगे
उसमें बेसिक उसमें
पेज नंबर
इंटरनल पेज 10
और द ट्रायल कोर्स
थोड़ा सा
कॉन्करेंट फाइंडिंग है कि रिवर्सल
कंकरेंट
तब तो और भी कोई दिक्कत नहीं
कंकरेंट लिमिटेशन के ग्राउंड पे मेरा फर्स्ट अपील गॉट रिजेक्टेड
बात ये है कि अच्छा लिमिटेशन के ground-
लिमिटेशन
और वो जो फाइंडिंग है वो इज रिलेटिंग टू लिमिटेशन होंगे
of the original courts it
दैट इज ऑन डिफरेंट पॉइंट
that what I can read madam what I can read is somehow
No, I want to know the appellate court judgment has been passed on the point of limitation. So far as the learning, so far as the eligible age of trial court is concerned, is it dealing with limitation?
no it records the details of exhibit and the PWs.
So that is limited. If the appellate court's judgment is sustained on limitation, the matter ends.
Absolutely.
If the appellate court's judgment goes on point of limitation, then it has to be remanded. क्या होगा इसमें? ये substantial question of law तो नहीं बना है
नहीं
आपका अपील टाइम बार था कि आपका सूट टाइम बार?
नहीं appeal time पर था. I was the defendant and the suit was set ex parte against me. Thereafter, when I came to know that execution case is pending against that, so I appeared and then I filed the first appeal. The first
While the learned appellate court has said that it is barred by limitation.
It is barred by 680 days. This is the finding given by the learned appellate court.
Did you file your petition for condonation or delay?
My lord, section 5. There appears to be an error while recording that when the date for when the record was set expired. I would find that at page 30.
It was said ex parte when you did not appear even after receipt of the summons.
The reason is the name of the plaintiff, the name of the defendant, who is the appellant before the lecture, is Pramod Kumar, and in the plaint the name is written as Pramod Lal. The address is Broad, Kilbal Colony, Ranchi, Hinu, Ranchi.
Your father's name is rightly written.
Because that has
Then
been
why did
taken.
you file the appeal? You should have said in the execution case that I am nobody.
But it pertains to my land. The case is for cancellation of my sale deed.
So you have a remedy, no, under law.
But
Because the identity is different, you are disputing your identity.
the plot, the land is very much referable to my sale deed. That is the reason. They wanted a declaration of right title interest and possession.
Your sale deed was exhibited.
Yes, it appears.
And what is the name? What is the name written in your sale deed?
That is correct. That is Pramod Kumar.
दिखाई दे exhibit कौन सा? Exhibit number बताइए.
पेज जो है पेज 10. the list of the original documents, whatever it is executed as exhibit 11. Give me the reference of the CLD. There is reference to my exhibit at internal page 13 of the original code at paragraph 19.
Basically, it can explain.
I have obtained a certified copy of it. I was arrayed as defendant number 6. Pramod Lal, wife of Sri Madhura.
Wife of.
Abdallah.
Okay, sir. The legal counsel for the appellant has submitted that records from the concerned court has been received. The records from the concerned court have been received, and page number 13,
10.
page number
Internal page
10
of the original course.
of the trial court's judgment. Judgment. Page number 13. ट्रायल कोर्ट जजमेंट का पेज नंबर 13 जिसमें है ही नहीं
13 10. Green sheet.
इसमें कहाँ है आप देखे हैं इंटरनल पेज 10
10.
internal page 10 of the trial court judgment is equally illegible, and there is overlapping of printing. The summit said the defect in connection with page number 10 of as pointed out by the office being known. Considering the submissions, the aforesaid defect pointed out by the office in connection with page number 10 is hereby ignored by the president. इसके अलावा कोई डिफेक्ट 105 का जजमेंट आपका कौन सा पेज पर है? Actually, what's judgment?
Starts with my memo of second appeal, my lord. It starts at present page 11, my lord.
Who is this case to order? Under order 41/11. For hearing under order 41/11. और तो कोई नहीं बचा?
नहीं, बस वही थोड़ा सा प्रेस करने से पढ़ने से समझ में आ रहा है। I will just tell you.
Let me do it. We'll see. Prima facie practice requires admission. You just prepare it. Very good time then. Very good time. कल से ऑर्डर 41 काराबटी हुआ। इसी हम लोग को सेकेंड हाफ में रखना चाह रहे हैं, तो उसको देखना होगा कि कैसे करना है। We'll figure it out.